Metropolitan members and friends, the privilege is ours this afternoon from the Health Ministries Department to share information with you designed to reduce stress and to help you through some of life's most difficult moments. The best thing you and I can do in this life is to be prepared, not just for this life, but for the life to come. And so this afternoon, it's with great pleasure that myself and my teammate, Sister Laverne Bruce, is going to share with you a very special individual who's going to share this information with us. But before we do that, let's make sure we've got the most important guests in the midst. Can you bow your head with me as we pray? Father God, thank you so very much for your love and your care for us. You've given us so much, and then we find that there's so much more you've prepared for us. We just want to say thank you. Thank you for this Sabbath day where we can pause for a moment and spend quality time with you. Be with those who are going to be hearers, be with our presenters in a special way. Lord, may everything that is said and done here be done to your name's honor and glory and the enrichment for those who hear. In Jesus' name is my prayer. Amen.
Amen.
Sister Laverne, I'm going to turn it over to you.
Good afternoon, friends and family, everyone. It is a pleasure to welcome you all to Metropolitan Health Ministries Department program today. We have put together something very special that we hope is going to be very helpful for all of you. Attorney Grace Semple-Paul is has been one of my dearest friends for almost the last 30 years. She is what I call a powerhouse woman. She's a mover and a shaker, and she's on my list of most admired people. So she is an educator, she's an informer and an advocate. She and her husband, Roger Paul, whom I have known since we were little kids, they parented 5 children who are now successful adults. She earned a BA in religious education from the University of the Southern Caribbean. Later, she migrated to the US and she earned a law degree from Cardozo University School of Law, the Yeshiva University in New York. Her experience includes lecturing at Antigua State College, interning at the Kings County DA's office, the New York County Clerk's office, and the New York Attorney General's office. After relocating to Texas, she started her own business as a business consultant, helping people to develop their businesses and also educating families in the important area of estate planning. While she continues to work in her business on a part-time basis, she's employed full-time as the Assistant Director of International Students and Scholar Services at the prestigious Baylor University in Texas. She is also, with all of that, an ordained elder with the Texas Conference of Seventh-day Adventists, and traveling and gardening help her relax. Please, I ask you to give her your full attention. I can't wait to hear what she's going to present because I know it's going to change all of our lives. Sister
Good.
Semple-Paul, over to you.
Okay. Good evening, everyone, and thank you so much for that warm welcome and introduction, Dr. Laverne. It is my pleasure to be here with you all this evening. It's um, it's the Sabbath day, and we look forward to rest. It's been already quite a full day for me. Um, I just came from a shower for my son's expectant um, baby. And I'm happy to be with you today to present Before I begin my presentation, I just want you to join me in acknowledging the critical historic event that took place this week when the vote was taken that ushered in Judge Ketanji Brown Jackson into the highest court of the land. I am so thrilled. We are so blessed to be living in such an important time in history, to know that our daughters will forever know that a Black woman is sitting on the highest court in this land. All right.
Yay! Yay!
Yeah, it's a big deal. It's a big deal for me. I'm going to go ahead and share my screen. I am here to talk with you about, okay, great. So I was invited to talk with you about 10 critical documents every home needs to have now. And I just want to set the stage for the presentation. I remember as a child growing up in church, listening to people sing and listening to people play the organ, the piano, and having all these talents. And I would keep asking myself, well, what is my talent? What is my gift? And I really could not figure it out. It took a while before I got to understand that my gifts are in the area of helps. And sometimes we kind of play down the importance of helps, but it is crucial and it's important. And even as we are living in these times, we see how much we need community, how much we need to work together to be able to uphold each other and to help each other. And so in my experience and in my careers, I found that I gravitate towards finding opportunities to educate, to inform, and to advocate. And in my years of working within the international student community, I have made the trip to Capitol Hill quite a few times to advocate on behalf of my students and scholars and others within my field. It's a very important part of what we as Christians need to do to be able to stand in the gap and advocate on behalf of those who are not able to advocate for themselves. And so as we have been going through the pandemic for these numbers is now years, you know, I've been talking with people and I've had people talk with me about the challenges that they've been encountering due to the sudden loss of loved ones. And so I realized it was important for us to begin to think about getting our house in order, putting our house in order. Some people are afraid to do that. They think that that means that you're preparing to die. But there's life and there's death, and we prepare for life and we have to prepare for the eventualities that come along with life. And so today I want to present to you 10 critical documents that you should begin to prepare and put in safe places in your home so that if and when you are called away, whether suddenly or whether expectantly, your loved ones are cared for. Your loved ones are not left to feel in a desperate situation. Let me share a disclaimer before I go into this. I want you to know that this list is by no means exhaustive. So I'm sure you can come up with other forms other than the 10 that I will present today. And also, this is not a lesson in law. This is an informational session. It's for information purposes. While I or anyone, many other people can assist you with some of these forms, I want to encourage you to speak to appropriate people who can assist you with your processes, such as a banker, or an accountant, a lawyer where necessary. Seek the professional help that you will need to be able to create the documents that we are going to be talking about today. So Three questions. My first question is, how many of you sadly lost loved ones or know of people who lost loved ones over the past 2 years due to the pandemic? If you would, maybe raise your hand in the chat or just contemplate the question. And to you, I offer my sympathy. And my next question, I'm seeing hands being raised. And the next question is, how many of those who passed on had the necessary documentation so that their transition did not disrupt the lives of those left behind? And again, I would ask if you would raise your hand if you know that these people who passed on were well prepared, had their house in order, so to speak, so that the transition did not cause a disruption to the lives of those left behind. And again, I offer my sincere sympathy, because it could really be a distressful situation. And then the last question for this here is, how many of you here in the audience have prepared the necessary documents to allow for a smooth transition should you become incapacitated or even pass away unexpectedly? And maybe I wouldn't ask for a show of hands. But I would say that if these questions make you feel uncomfortable, I would encourage you to keep listening, as what I'm presenting today is intended to be a solution-based presentation. And so let's look at what I would suggest as the first document that you should have. And that is the last will and testament. The last will and testament. I'm going to ask the question anyway. What is a will? And I will answer it. A will is a document that tells the court what to do with the assets in a testator's estate. So the will is the testator, or a person before death, of course, instructing the court on how they would like to have their assets distributed. There is no higher limit and no lower limit to what you can place in a will. We would usually hear people say, I don't have anything significant to leave behind. I don't have anything that needs to go into a will. But remember, if you own anything, you can create a will. A will can be as formal as having a meeting with an attorney, having witnesses sign and safely filed away, or it can be as simple as, and this is in some states, I know in Texas, a handwritten will, which is called a holographic will, can be scribbled even on a napkin. There is a case of such, even on a napkin, provided it states the desire, the wish of the testator, and to whom the testator would like the assets to be distributed. I would dare ask, do you know that there are many people, even very important people, such as Aretha Franklin, such as Prince, who died without leaving a will? And can you imagine the number of years that is spent trying to decipher, trying to figure out what to do with the estate left behind? Creating a will can be seen as an act of kindness that shows how much you care about the people who are left behind and how much you care about what you have acquired over the years. And so it's your way of saying, these things are important to me, these people are important to me. So I will let them know how I want my assets distributed. There's an old saying that goes, where there's a will, there's got to be a way. And I would say, but where there is no will, there is no way for the courts to know how to distribute your gifts. And so they'd have to go through, the courts would have to look at your, try to figure out your intent. What did you do with, or who, to whom did you distribute some of your previous gifts? And they'd have to try to figure out um, who's the next of kin, who should have, and it becomes quite um, a confusion and often brings enmity between family members. We don't want that to happen. So I encourage you, make a will. We know that a will has to be probated, means that it has to go through the court, and then the court has to validate the will. In the state of Maryland, it can take about a year to validate a will, to probate a will. And recently, due to the pandemic, we know that courts have had huge backlogs, and so it may be even a little longer time. So while it's important to make a will, I want to go on to the second form that's important. And we want to suggest that in addition to a will, you should create what is called a revocable trust. And so the question is, why isn't a will sufficient? Well, there are a few things about a will that you should know. One is, and I stated it, it takes about a year to probate a will. Two is, a will is a probated will is a public document, which means that after the will is probated through the courts, the will is published so that anyone can go and look and see to whom your assets were distributed. Not everyone wants people to know everything that they have done. And so for that reason, there are some items or assets that you may not want to put in a will. And by the way, if you want to, just go ahead and Google the last will and testament of Jackie Kennedy Onassis, and you will see her entire will published, because any probated will becomes a public document. So that's another reason why some people may not want to put everything in a will. And then another thing also is that there are court costs involved in probating a will. And so we suggest that there are some items that you may prefer to not have go through that entire year or longer, because you want your heirs or your beneficiaries to have access to certain items. Especially if you have children under the age of 18 that you need to have cared for, school fees to be paid, their basic upkeep. You don't want them to have to wait a year, because I should say that when a person dies, their assets are frozen. And so one of the suggestions is that you set up a revocable trust. It's a simple document through which you can pass certain, or you can, pass certain assets, such as real estate property, such as investment accounts. If you have an LLC, you can put an LLC in a trust, virtual assets, crypto coins, even vehicles, precious jewelry, fine arts. These can be placed in a trust. So you would set up a trust, and then you would transfer the title into the trust for these items. That way you bypass the court. These items never have to wait for a court order. As once the truster passes away, then the person who is the beneficiary just needs to show the trust to the bank or to the real estate owner or the investment company, and then the asset is released to that person, totally bypassing the court. All right, and so that's our second document. And before I move off, I'm sure some of you have done this. Some parents would set up a bank account in trust for their minor children, and that can be done. Just be careful to ask all the correct questions of the bank to make sure that you're clear about tax implications and about at what time that child can have access to whatever is in trust. So that would be important for you to take note of. Okay, so that's the revocable trust. It dictates which assets can be distributed outside of probate, and it can be revoked at any time. So you can change your mind, you can change whatever is in the trust. And also, key thing to remember is that it becomes irrevocable when the trustor dies. It becomes irrevocable when the trustor dies. So whatever is in there has to remain as is and distributed accordingly. The third form that we will look at is the letter of instruction. The letter of instruction can be a supplement to the will. This can be a supplement to the will. And this is you leaving instructions so that the executor of the will, or so that the trustee who is holding the trust, or it's just so that people in your life can be acquainted, can be aware and have contact information for your attorney, for your accountant, for financial advisor, for your pastor, whoever are the persons that need to have a role in your, whether it's your funeral arrangement or in the distribution of your assets. This should be left in a place where it can be found. Some people choose to leave it in a Bible. Some people leave it in their safety deposit box. But it wouldn't make sense for you to prepare a letter of instruction and then you tuck it away so safely that no one can find it. So make sure it's in a place where it can be found once you have passed away. And that's up number 3. We go on to number 4, very important document, a durable financial power of attorney. I believe in the state of Maryland, it's called the statutory financial power of attorney. This is a document that some often think that only millionaires and billionaires need to have a document like this. Everyone needs to have a document, a financial power of attorney. This is the document that I got calls about more than any other, because when people took ill suddenly and became incapacitated, family members were left not knowing how to access bank accounts, how to conduct the business that was left behind. Total chaos because there were no instructions left. This form is, as I said, statutory because it's usually, are you still seeing my screen? Okay, yes. Because it's usually governed by the laws of your state. In the state of Maryland, for example, it's governed by Title 17. And if you create a durable power of attorney for, what do we call that again? A limited power of attorney, then you're instructing a person to do maybe one specific task for you, maybe sell a building so that they can be enough money to pay your hospital bills or to keep your family going. So you can create a durable financial power of attorney that gives a person, your agent, one specific responsibility. And in Maryland, that's governed by Title 17-101. Or you can create the general power of attorney, and that's governed by Title 17-204. And that gives full power to an agent to execute any business on your behalf. Just be careful about to note this fact, and that it is possible that that person can execute business even when you are not incapacitated. So you want to be careful to make sure that that document is properly written and limited in whichever ways you would want to limit it, so the person does not have powers beyond which you want them to have. But the benefit of having this form is that it releases your family from undue stress of trying to figure out where things are and how to conduct your business. So that's the durable power, financial power of attorney. Our fifth form is a list of all bank accounts and online login. There used to be a time when we probably had one or two bank accounts. Now people tend to have several bank accounts. They are brick and mortar banks, they are online banks, they're all types of financial institutions, and we all have login information for them. We have passwords for them, and we need to have all of that information in one place, or in a safe place, in an accessible place. Banks need to be informed when a person is incapacitated. They need to know who is the agent that can access accounts. If not, the accounts are going to be frozen and no one will have access. We have all types of accounts. We have social media accounts. We have to capture that information and keep them in a place that is accessible to your loved ones. And that's Form 5, a list of all bank accounts and online login information. Form 6, we're talking now about a list of any safety deposit boxes. Safety deposit boxes. Usually people keep this very secret. Some people don't even want you to know they have a safety deposit box. That has to change to some extent. It is important that you let your spouse, you let your children register with the bank so that the bank knows who else can access the safety deposit box, especially if you have all your important documents in such a box. I recently heard of a case where person was deceased. No one knew where the key to the box was. No one knew how to access the box, the safety deposit box. And this had to be taken to the courts because the bank was reluctant to have anyone come in. Of course, there's no document giving them permission to allow anyone else to access the box. And the next recourse would have been for the bank to basically blow up the lock to access the documents. And that all had to go through the court that is already backlogged. And so there was a family waiting and waiting and waiting and being delayed further and further because no one knew where the key for the deposit box was. So it's important that someone else other than yourself knows how to access this safety deposit box or boxes. And the same thing would go for storage units. People also have storage units where they have important assets and stuff put away. Someone else needs to know how to access that. And then we get to number 7, the durable healthcare power of attorney. Durable healthcare power of attorney. Most important healthcare document that you need to have. It is often a part of the advance directive where you make a statement of the circumstances under which you would like or would not allow various types of medical procedures to be used for your benefit. This is where you designate someone to make those types of healthcare decisions for you if you are incapacitated. A few years ago, we faced this dilemma when our mom was suddenly slipped into a coma after medical errors and could not make decisions for herself. And we did not have such a document at that time. And we had to, my dad, who was already in deep distress and, you know, had to be the one to try to somehow figure out what she would have wanted if she could make these decisions for herself. We don't want to have people placed in those kinds of situations. So we need to go ahead. We don't need to wait until we get sick because accidents happen, pandemics happen, boulders fall off the hills, just things that are totally beyond our control. So we have to be proactive. Go ahead, create that document, keep it on file. It gives information about your insurance, it gives information about key medical personnel. Um, Also, it's the standard form used and designated by hospitals and your state. And I'm sure if there are questions, we can deal with this some more. But that durable healthcare power of attorney, please check on your state website, see what it looks like. Don't wait until you're wheeled into a hospital or until your loved ones are incapacitated to begin to figure out how do I deal with this. And then and then the other medical form is the authorization to release protected healthcare information. This is you authorizing a person or an agency to release protected healthcare information. Um, and again, this is done through contacts with your insurance company or medical personnel. And there is a state form that you can download from your state website. This can be done together with the durable power of attorney, or it can be done separately. It depends on the need and the circumstances and also on your desire. But also make sure you have prepared somewhere that authorization to release protected healthcare information. And you see this becoming necessary when you're out of state or even if you're out of country. It becomes even more important to have a document of this type. And now we're getting to number 9, and that's the living will. Some people think this is necessary and some people don't. I think it is important to have a living will. We commonly talk of it as a DNR, do not resuscitate, or a healthcare directive. And this is where you are saying, if I should become terminally ill, how do I want? What is my desire? What do I want my loved ones to know about whether I want to die naturally, whether I want to be resuscitated, to what extent, when, is it after 2 or 3 tries? Is it after the first try? Do I want to be placed on life support? Am I interested in hospice care, palliative care? Do I want caregivers in my home? Do I want to be taken home or do I want to be at a hospital? This is where you let all your desires known. And again, if you're going to create these documents, make sure they're in a place, make sure you notify someone so that they know where to find it and so that they can have your desires met, and they can relieve the family from some of the stresses that ensue from not knowing your desire. And then the last form, Form 10, it's like a catch all, but I think it's important. It's a form that I call make a plan form. Make a plan. Make a plan. People are usually timid about making plans. They think you're flying in the face of God. They think it means you're not trusting God. But God gives us wisdom and He wants us to plan. He says that He will approve our plans, or He may even disapprove it. But if we have a plan in place, He will. There's a verse that I really like. Proverbs 16, Proverbs 20, verse 3, I believe it is, that says that He approves our plans. He says, commit to God whatever you do, and He will establish your plan. That's it. Proverbs 16, verse 3. So create your plan based on the wisdom and the knowledge that you have gained and that God has given to you, and present it before Him and let Him establish it. Let Him show you your next steps. This is important. I listened last week to two young students. They're actually from Jamaica. They were sharing their experience. They were in the Ukraine when the war started, and they were sharing their experience about the kind of networking, the kind of planning they had to put into place, almost a buddy system with other international or foreign students who were in the Ukraine in order to get out of the Ukraine. And, you know, many of us live in hurricane zones. We live in tornado alleys and snowstorm spaces. And these days with climate change, there's no telling what could happen where. Do you have a plan in place that tells your children or tells your spouse or loved ones how to reach you if you are caught in some natural or other disaster? How do they reach you? And I know we rely on the phone a lot, but what if the phone system fails? Is there some kind of a code that your children are aware of? Is there a place where you all will meet if something goes wrong? Is there some plan in place so that people will know where to find each other eventually? So think about that and develop a plan and commit that plan to the Lord and let Him direct your paths. Thank you.
We're going to now go into our question and answer period. And I'm going to let Laverne take over and do our first three questions. If you have additional questions, please feel free to put it in the chat and we'll make sure that your questions are heard.
Thank you so much, Attorney Semple-Paul, for that. Was really amazing, extremely informative. I know some of those things I have not done, like making up a family plan. I think that's very, very important one because we all know we've all had snowmageddons here in Washington, D.C., where our kids were gone and took hours for them to get home. So really, thank you so very much for taking the time to put this all together to help us. I have a couple of quick questions. I have a couple of quick questions. The first question I would like to ask you is, what would you say is one of the worst situations you have seen when none of these plans were in place? Did you hear me? I'm not
Uh,
sure.
yes, I hear you. Um, There are several, and I'm sure if we poll the audience or ask the audience, they can share some situations that they have faced. But I've been talking with a young lady whose parent, one of her parents passed away, and she was left with um, she thought that she was the executor, and this is addressing even the will. The reason why I titled it "The Last Will and Testament" because people make wills, you know, they may make a will here, create a will here, and then they put it down, and then they maybe get upset with a person or another, or they may have a new person introduced into their lives, and they want to leave something for that person, so they create another will, and then they may create another one. And this was a case where the mom had created more than one wills, and so what she thought was the last will was not, and so the will that was brought before the court was not consistent with the will that she had in her hand. And so you can imagine how distressing this was for her, because the mom had spoken with some of her children and told her that she had left them certain things, but she hadn't had the time, or she hadn't taken the time to include it in the will. And so there were some children who were thinking they had right to certain things, and there she was thinking they didn't have right because their will did not include, did not have the same information. So I want to make the point that talk with your loved ones and make sure that whatever they create as their last will and testament is what is the one that you are able to file or put away in a safe place. And also that any other wills are destroyed, because that is a situation that can lengthen the time that is spent in the court. Because now, instead of spending 1 year in the court, you could be spending an extended period of time when people keep um, contesting the will and contesting the will. And I've known of cases where houses fall into disrepair because there can be no agreement on who is should be the owner of the home. So that's one that comes to mind.
Okay. How would you say that the pandemic has brought some of these issues to the forefront?
Oh, I'm sure you will agree with me that if you hadn't thought about the importance of protecting your assets and protecting your loved ones, the pandemic certainly brought that to the forefront. As you watched, seemingly healthy people just becoming incapacitated, and in so many cases just dying, and leaving behind young children and young families just not catered for, just not having a plan in place. And so if at no other time, this time has brought to us an awakening. It's a time for us to just sit honestly with our families. Many of us are Caribbean people, and for some reason, Caribbean people are afraid to make wills. They're afraid to stop and think about, estate planning. They think for some reason that means they're preparing to die. But that's okay. It's okay to prepare to die. It's okay to prepare to die while you're living, because it's a part of the continuum of life. And so we have got to take the time to sit with our families. If we have elderly parents, sit with your parents. I saw another a situation where um, a friend, both her parents ended up in the hospital, both on what do you call it, on oxygen, and the parents had business, and this was an adult child, and she had no idea about where the bank accounts were. She had no idea about how to even get the funds needed to keep the business going because her parents could not speak. They could not speak. And she was totally at a loss trying to figure out what was her next move. We are way too intelligent to allow circumstances to dictate the next event in our lives. We need to just be for, forceful, sit with our families and make them listen to the importance of putting our homes in order for the benefit of others.
Do you have any tips for helping to broach this psychological problem if children want to sit with their parents and discuss this? This might be a tough question, but because some parents are very reluctant. But do you have any tips for how children can approach their parents with that?
And that's an excellent question. And um, I could say what I did with my dad. I made a surprise visit. That I knew that that wasn't something I could do on the phone because I don't live in the same state with him. So I made a surprise visit to see him, and of course he's happy to see me. And we sat and chatted about a lot of other things, and had some great conversations, and and then we got to chatting about what do you want, what would you want to happen with the property you have here? What would you want to happen? Just in a casual conversation. It probably may take time, especially if you haven't had this conversation before. You may have to have several short, gentle conversations and then build up to, um, can we put this in a document and have you sign it? So I had to do the gentle conversations. And I know for him, he was happy to begin talking about what he wanted to happen to his properties, because he didn't want him to go into disrepair. People want a legacy left behind. They want to know that they're passing things on to their children. Sometimes they don't know how to do it. Sometimes they themselves don't know how to start the conversation. So that would be my suggestion. Short,
Mhm.
friendly gatherings and conversations until we could get to the topic and make it into a document.
Mhm. Now, people often think about wills and trusts and these things as the purview of old people. Would you say that as long as you're above 18 and you own anything, that you should start thinking about some of these documents?
Yes, yes, I totally agree with that. I would say that, um, and I think for young people, it should make them feel important that they own something that they can pass on, that they can leave for someone else. Um, so as a young person, get in the habit of documenting what your assets and putting them in safe places. It's sad to say that it's something it's almost cultural that I don't know if it's only cultural, but or if it also has something to do with our religion, that we place such little value on things we spend so many years working on. And so we don't think of what's the word I'm looking for, of documenting, and assessing the worth of the things we own. It's important that we do that. We worked for them, we labored for them, and we don't want them to fall carelessly. You die, and then there are people fighting over your property, and there's no agreement, and so it sits there, and it just falls into disrepair. When the difference would be so simple if you have just documented what you wanted to happen to them. So it shouldn't matter your age. And to me, the younger you are, the more pride and joy you should have about being able to document that you own this property. And if I'm not here, this is what I want to happen to it.
Yeah, I had a young friend who died very suddenly in a car crash because he had seizures. And he left a townhouse, a car, and that townhouse was filled with all kinds of things. And so it was a very difficult situation for the family. Someone in the chat just mentioned that they missed the first document that you mentioned, which I think is the will, correct?
Yes.
But I also want to let people know that Sister Ihime, our communications director, is going to post this on YouTube in a couple of days, so it will be available for rewatch.
Okay.
Any-
And also, whatever we talk about here, we are going to, you will have the opportunity to pick up copies of some of these documents specifically for the state of Maryland. Our church secretary has graciously consented that she knows that our seniors like to have something in hand. So we will
Mhm.
make sure that we will print off the state of Maryland's form, which is called the MOLTS, and she will have copies of it for you at the church's office so you can pick it up there. Please note that the MOLTS is not a legal document until it is signed by your physician. And the recommendation is that we keep it either next to your bed or in the cupboard or cabinet nearest your refrigerator, as the EMS folks are trained to look for it there. Attorney Grace, we have a few questions in the chat that I'd like to share with you in the time we have left.
Sure.
Um, Question. Many poor families believe only people with money or extra money can write or afford a will and not them. How do we help families without major assets write a will?
Hmm. And that is a very good question, and that's the fact that we face, all the time. People are saying, I don't have anything to leave, or I can't afford a will. A will be held valid by the court, even if it is written without the signature of an attorney. In most states, a will is considered valid if there are two witnesses to the signature. Okay, so if you write up your wishes, basically identifying yourself, dating it, identifying who the beneficiaries or the heirs, and then you sign it with two witnesses. It's usually best, for you to name an executor, right? So you're naming who you would like to be responsible for distributing your assets. You name yourself. You name the beneficiaries. You can also name a replacement executor in case that person dies before you. And another statement, it would be good for you to say, if, let's say, you name your daughter as your heir, and but your daughter predeceases you, then you would say then to maybe your daughter's children. You know, those are basically all you need to list there. So if all you have, for example, is the house you live in, and you say, I, Grace Semple-Paul, on this specific date, leave my house to my daughter, and should my daughter predecease me, then to her daughter. Um, and then you date and you sign it, and you can also leave your daughter as the executor. And you date and you sign it, and two people witness that you have signed it, and then they sign below stating basically, I've witnessed that this person signed. That will be considered a valid will in most courts,
All right.
right? If you
Yeah.
have more, the more assets you have, the more likely you are to need an attorney to sign, to sign off on it. But if you just have a few basic assets, then you can have it done yourself. You may want to have an attorney or some other knowledgeable person to look over it and to make sure you have all the pieces in place, and then you file it away or keep it in a safe place. That is better because the judge is going to say, this is what the person intended if there's nothing else there, right? And that is way better than leaving absolutely nothing and no one knows what your intent is.
Okay,
Is an
next
option
question.
also, I'm sorry, may I jump
Go
in
ahead.
real fast? Sorry. Is there also an option to use a notary public? Does that make it sort
Yeah.
of stronger legally?
Yes, you can. You should use a notary. Even with the signatures, it would be best to have a notary um, public just confirm, notarize everything, all the signatures. Yes, thank you.
Not a problem. The question is being asked for the molds. Are you referring to the healthcare power of attorney or an authorization for release protected health information? The advance directive does the releasing of the information. The molds for Maryland just say what your wishes are, and it's really just healthcare. The next question is, how would you suggest broaching the discussion of this topic with elderly parents who are afraid to talk about wills and estate planning? For example, what leading phrase would you suggest?
I am laughing because I have family members that are not even elderly who I am having such a challenge having this conversation with. Drawn up all the papers and basically put it in front of them for signature. And, you know, um, I would say have the conversation. Just have a friendly, you know, mom or dad, you have this house here, you have this whatever. Who do you want to have this house, if you're not here? Just have this conversation in a friendly way with
Mm.
them without the papers. Don't bring any papers into view. Just have the conversation,
Si- Sister
and that.
Veronica followed you by saying you have sometimes to ask one question at a time. Multiple questions may be too overpowering.
All right.
From Deborah, she states Caribbean parents truly filled with lots of taboo. We have given up trying to make arrangements for mom's funerals or wishes to buy a plan. She refuses to share social security numbers or have an open plan. So
Mm,
now what? What
mm.
do I do to avoid being taken by surprise?
Some things will come only by fasting and prayer. I know those challenges. I know. I don't know how you rewrite that story for our elderly parents. I don't know. I don't know if I think they think that, once they're not here, they have nothing to worry about, and they don't understand that, you know, a, I know a brother and sister who were the thick as thieves. They hung out, they did everything together until mom died.
Mm.
And she was just shocked to know that he went behind her back and tried to change documents and do all sorts of things. And now they're not, I mean, they're the furthest apart. How do you get your parents to see that? I don't know. I think you just, you have to find a way to not let them feel like you're coming at them, but just that it's their best interest, or if you know who they want to benefit from whatever they're leaving behind, have that person talk with them. I don't have an answer that that is going to work in every
Yes,
scenario.
yes, yes. The next question is, um, there was a will that includes the personal residence and assets to be left to someone, but it happens that both husband and wife health deteriorated and they're now in long-term care facility. How does the will fulfill, how can the will be fulfilled with that situation?
Right. So a will only becomes effective when the testators, or when the person dies. So even though they are incapacitated, there's nothing that could be done with the will. The
Hmm.
will just it remains as is until they pass away. And that could be the benefit of having trust, you know, because it's possible for you to put your residence in a trust. You just need to remove the title and everything into that trust, so that if a person becomes incapacitated, the trust protects, right,
The
that
asset.
asset, right? And so you know that it's going to pass on to the person, and the person can still, benefit, because it's in trust for that person, right? So if the person wants to live there or whatever, the trust stands. You see what I'm saying? The
Yes,
trust remains, and the trust is effective from the time it is created.
yeah.
And one
The caveat she has to the question, sorry, Laverne, is that the asset, I guess, needed to be sold in order to pay for their care while in the facility.
Mm-hmm.
So does the person that it was willed to then not benefit from the will?
Um, can Who is going to sell it? How is the person going to get what gives the person the right to sell it?
Well, some facilities are now asking if you don't have the asset liquid, they will accept your home as the payment
Mm-hmm.
for your care.
Mm-hmm.
So I guess that's what she was asking.
Right, but they're incapacitated, so they cannot give a word about. So that now becomes. I mean, the person can seek recourse from the courts, but that will be quite a challenge, because persons are incapacitated. Both parents are incapacitated and cannot give a word. Um, that's a challenge. That's one that definitely need to talk with an attorney about. Well, what will happen basically is that if the property is sold, then there is no asset to be distributed at the time of
You
the
will.
will. You know.
Correct. Next question. I've heard that wills should be registered. Are there any formal registration process for the other documents that you mentioned?
No,
Okay.
no.
Next question. For, for parents who have many children, some feel entitled to more than others. It is a private document. Is it a private document legal without informing any of the children? Also, parents have hesitated to do so as history shows that children sells the property and
Mhm.
exclude others.
Mhm.
Yeah, those are all cases that we have seen before. And one of the reasons why people tend to have a will and put it away so that it's not available for all to see. Um, and people may file it away with an attorney or file it away with the person who they have asked to be the executor, put it in their care. Those are all ways that people try to safeguard information before they pass on.
Yeah. The suggestion is being made that maybe the pastor needs to start to have that conversation with some of our senior members so they understand the gift they're giving to their children by having the conversation.
Yeah.
Nice suggestion. That's from Dorel. Um,
One quick suggestion,
Go ahead.
Ursula. Language is a very, very powerful thing. There's a there's no difference between a used car and a pre-owned car, but pre-owned just sounds a lot better than used.
Mm,
And I wonder if with our Caribbean parents, if we shouldn't focus more on the word trust rather than the word will. Will implies death. You're gone, and you don't want to think about that. But trust is a word a lot of Caribbean parents are familiar with because they're familiar with getting trust from the stores and so on and so forth. So maybe we should bring up these issues in the context of mom. Can we talk about how you can create a trust so that if
mhm.
something happens suddenly, I would know what to do with your things to make you happy.
I
I
like
think
that.
that it might just be a difference in the words.
Hmm. I
Its
like that.
connotation is better.
Hmm.
I like that idea. Having had my own experience, I think one of, and I am a nurse, so I'll put that caveat there. I see too many of our parents, patients, who at the time of where where decisions need to be made, sometimes we have all out brawls in the hallways of our hospitals and healthcare institutions because the family does not agree on,
Mhm.
especially God forbid you hear the doctors saying there's nothing else we can do for you, we have to remove her from life
Hmm.
supporting systems, and then the family is in, at a time when we need each other, we're fighting
Hmm.
because one does not believe that this is what mom would want, or
Hmm.
somebody believes something totally different. But what a peace we can give as a gift
Hmm.
when my children don't have to make that difficult decision
Yeah.
and you don't have to fight over such things.
Mhm.
Yes. Yes. That's the goal. That's the goal.
That's
And maybe,
another
and
way.
yeah,
Yeah.
and maybe you're right. If the person who shared, maybe if we talked more about this in church, if our pastors and would include this real life um, situation in their presentations, it probably will bring the tone down a bit.
But as you said before, Deborah is making the point that not only for our seniors, but for our youngsters also.
Mm,
I know today while we were at church, a lot of our youngsters were really a little distraught because one of the football players was hit by a truck and killed.
mm,
And they're like, but he was so young. And it really goes to show that life is not promised to any of us. And so
mm.
each of us need to be ready
Prepare.
and prepared for this. We have to live with intentionality and purpose. And so
Yes.
um, I just want to, our time is far spent, but I just wanted to say thank you, thank you, thank you for sharing this very, very important information with us. I know we've had several folks from different churches, so I want to welcome you. Our virtual church of Metropolitan is
Mhm.
open to all. Please, please, this video, this recording will be live on our church's website, metrosda.org. Please not only go back and review, but also share it with your family and friends. As as people of African descent, we are at times at greatest risk for lack of knowledge. We want to move the needle to the right. Let's do it.
Mhm. Yes.
Any
Yes.
last words? Any last questions before we close?
I have one quick comment, which is what was very sobering to me when I found this out. I don't know if this is still true, but I understood that in the state of Maryland, if you die intestate, i.e., if you die without a will, all of your assets go to the state. So I think is that true? Grace, I don't know if that I was told that, and so that to me is a motivating factor for Caribbean
Mhm.
parents or any parent who worked hard to accumulate some assets to realize that if you don't decide who's going to get it and you die without a will, the state is going to get it, or the state will have to decide who
Mhm.
gets it after people petition.
I I believe that most courts will will look for next of kin, um, and I think they will do everything possible to find next of kin. If they're unable to find any relatives, then it will go to the state. But I believe most courts will try to find the next of kin.
I know one of the things that I found very nerve wracking as I took care of my father's funeral recently is that the attorney at the courthouse that I spoke to um, told me that regardless of how little he had we put his assets in the trust, we would not have had to pay the probate costs.
Of
The
course.
probate, and this is where most families get tripped up because the probate cost is a percentage of the value of the estate.
Mhm.
Now, fortunate for me, my dad's assets that was left kind of in limbo was very limited. But if you have homes or whatever, and then
Mhm.
you can't pay the probate costs, that's where things get left to the government. So even as you age, um, most of my patients are shocked to find out that they're not qualified for government help because their homes put them over asset, over the limit of assets. And so they're not able to get any help.
Mhm.
However, if you put your assets in trust after 5 years, you are qualified for state
Mhm.
help.
Mhm.
So
And that's
just a
another
thought.
topic. That's another topic that it should be presented on.
Yes.
Yes, how to protect those assets.
So how to protect that asset.
Mhm.
And all of this really comes down to peace of mind and
Yeah.
reduce stress so that we spend the last moments or days with our loved ones not worrying about stuff
Yes.
that's not
Yes.
important. I just
Yes.
want to say thank you, thank you, thank you for all who came on and listened, all who will share this information,
Mhm.
but a special thank you, Attorney Grace and Paul, for your lovingly presenting this challenging topic for us.
Thank you.
And thank you, Sister Bruce, for recommending her. Thank you so very
Amen.
much. We will close with prayer. And again, please look forward to our next topic. But most importantly, don't keep this information to yourself. Share it so that others can also be ready. Let us pray. Loving Lord, we just want to ask that as Grace has so graciously poured out to us, we ask God that you will pour back to her an overflowing blessing. Be with her in her work, be with her family. Help as she continues to teach and support others, that you in turn will just continue to support and bless her. Be with us as we depart from each other, and may we forever be a blessing to those we come in contact with. In Jesus' name we pray. Amen.